Counsel, is it acceptable for us to agree that the court can read the jury instructions and not require them to be reported, the actual reading of the instructions? Mr. Smith?
Yes, Your Honor.
Mr. Sheldon?
Yes, Your Honor.
Ladies and gentlemen of the jury, we are now at a point in the trial where we're going to have closing statements, and I'm going to read to you most of the instructions. The way this will work is I will read to you the bulk of the instructions, and you've been provided copies of them. The reason that I do this first is because the attorneys will want to refer to these instructions in their closing arguments, and so I want you to be acquainted with them to assist them in their closing arguments. The state will first give its summation. The defense then gives their summation and closing argument, and then the state gives its final closing. Let's begin with reading the instructions. Instruction number 1. This is a criminal case in which the state of Iowa, hereinafter referred to as the state, charges defendant Scott Carl Pfister, hereinafter referred to as defendant, by trial information with the crime of sexual abuse in the 3rd degree. The defendant has pleaded not guilty. Instruction number 2. The trial information is the document that formally charges the defendant with a crime and is merely the method by which the defendant is brought into court for evidence or trial. It is not evidence. Instruction number 3. The defendant has entered a plea of not guilty. This plea of not guilty is a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Whenever I instruct you that the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 4. The defendant is presumed innocent and not guilty. This presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial, unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 5. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. You must consider all of the instructions together. No one instruction includes all of the applicable law. Instruction number 6. The duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 7. Nothing I have said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 8. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing character that a reasonable person would not hesitate to rely and act upon it. However, proof beyond a reasonable doubt does not mean proof beyond all possible doubt. If, after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt and you should find the defendant guilty. But if, after a full and fair consideration of all the evidence, or lack of evidence produced by the state, you are not firmly convinced of the defendant's guilty, then you must have a reasonable doubt, and you should find the defendant not guilty. Instruction number 9. You shall base your verdict only upon the evidence in these instructions. Evidence is testimony in person or by deposition, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. Stipulations, which are agreements between the attorneys. Any other matter received into evidence. Sometimes, during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence: statements, arguments, questions, and comments by the lawyers, objections and rulings on objections, testimony I told you to disregard, anything you saw or heard about this case outside the courtroom. Statements and questions by law enforcement officers during an interview with the defendant are not evidence to be considered for their truth. The defendant's answers and responses to those questions and statements are evidence. Instruction number 10. In considering the evidence, you may make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show the defendant is either guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 11. Decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. There are many factors which you may consider in deciding what testimony you believe, or what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 12. Evidence has been offered to show that the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence, just as if they had been made at this trial. You may also use these statements to help you decide if you believe the defendant. You may disregard all or any part of the defendant's testimony if you find the statements were made and were inconsistent with the defendant's testimony given at trial, but you are not required to do so. Do not disregard the defendant's testimony if other evidence you believe supports it, or you believe it for any other reason. Instruction number 13. To commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 14. The state must prove all of the following elements of sexual abuse in the third degree. 1. That between May 1, 2005 and April 30, 2006, the defendant performed a sex act with Kayla Smith. 2. The defendant performed a sex act with Kayla Smith when Kayla Smith was 14 or 15 years old and either of the following. A. Kayla Smith was related to defendant by blood or by affinity to the fourth degree. Or B. Defendant is 4 or more years older than Kayla Smith. 3. The defendant and Kayla Smith were not then living together as husband and wife. If the state has proved all of the elements, the defendant is guilty of sexual abuse in the third degree. If the state has failed to prove any of the elements, then the defendant is not guilty of sexual abuse in the third degree. A nephew or niece and their uncle are related within the fourth degree of affinity. Instruction number 15. Concerning element number 1 of instruction number 14, sex act means any sexual contact. 1. Between the mouth of one person and the genitals of another. Or 2. Between the finger or hand of one person and the genitals or anus of another. Or 3. By use of artificial sexual organs or substitutes therefor in contact with the genitalia or anus. You may consider the type of contact and the circumstances surrounding it in deciding whether the contact was sexual in nature. Skin-to-skin contact is not required in order to establish a sex act. Instruction number 16. Concerning element number 2 of instruction number 14, the state must prove that Kayla Smith was 14 or 15 at the time of the defendant's act. Instruction number 17. You have heard evidence that the defendant allegedly committed other acts with Kayla Smith after the time frame of the offense charged. If you decide the defendant committed these other acts, you may consider these acts only to determine whether the defendant has a sexual passion or desire for Kayla Smith. You may not consider them as proving that the defendant actually committed the act charged in this case. Instruction number 18. During the trial, you have been allowed to take notes. You may take these notes with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impression of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. We're going to stop there because the balance of the instructions pertain to the manner in which your deliberation will be conducted. So we'll review those at the close of the closing arguments.